Welcome to Hot Topics in U.S. Copyright Law, a webinar based on the article Review of Some of the Most Important Cases of the Year in U.S. Copyright Law 2020, which is published online and appears in the June 2021 edition of the Journal of Intellectual Property Law and Practice. Today's presentation is by Amster, Rothstein, and Ebenstein, a firm which specializes in intellectual property law, and is brought to you on behalf of the Journal of Intellectual Property Law and Practice, as well as Oxford University Press, its publisher. The following presentation reflects the personal opinions of its authors and does not necessarily represent the views of their respective clients, partners, employers, or of Amster, Rothstein, and Ebenstein LLP, the Journal of Intellectual Property Law and Practice, or Oxford University Press. Additionally, the following content is presented solely for the purposes of discussion and illustration and does not comprise, nor is to be considered as, legal advice. After the presentation, Charley Macedo and others will do a short Q&A answering written questions. Please type them in the Q&A tab throughout. We hope you enjoy our presentation.
Hello, I'm Sarah Harris, Managing Editor of the Journal of Intellectual Property Law and Practice, published by Oxford University Press. I'm delighted to welcome you today to a webinar on hot topics in US copyright law, with a superb panel of speakers. Today's speakers are the authors of an article that appeared in the June issue of the journal, a review of some of the most important cases in 2020 in US copyright law. The article is currently freely available on our website, so do take a look. As I said, we have a superb panel of speakers, and I'd now like to introduce Charley Macedo, partner at Amster, Rothstein and Ebenstein, and a member of the journal's editorial board. Charley will be moderating today's discussion and introducing the speakers. Charley.
Thank you, Sarah. As Sarah explained, my name is Charley Macedo, and I am a partner at Amster, Rothstein, Ebenstein LLP, an intellectual property boutique located in the United States. I will be the moderator and sometimes a presenter in today's webinar. Today, we will be discussing some hot topics in copyright law from 2020 with a supplementation of some more recent cases. When Sarah first approached us to write an article about hot topics in copyright law during 2020 for Oxford's Journal, we were all in. We prepared the article that is the basis of today's presentation, which is being published by Oxford in the June 2021 issue of the Journal of Intellectual Property Law and Practice. My colleagues David Goldberg and Chris Lazinski helped prepare that article and will be joining us in today's presentation. We will also have other colleagues from Amster, Rothstein, and Ebenstein join us as we discuss a wide range of hot copyright topics and cases. We will begin today's webinar with the discussion led by me and my colleague Chandler Sturm involving two copyright decisions decided in 2020 by the U.S. Supreme Court involving states' rights and responsibilities in copyright law. The first case, Allen versus Cooper, is based on a factual dispute regarding videos made in the search for Blackbeard's pirate ship called the Queen Anne's Revenge. It stands for when states like North Carolina can or cannot be sued for copyright infringement. The second case, Georgia versus publicresource.org, is based on a factual dispute of who owns official annotations to state codes and the so-called government edicts doctrine. Next, my partners Chester Rothstein and Holly Pekowski will discuss a series of decisions coming from the federal courts located in New York involving social media and the republication of photos using embedded links from Instagram. Third, my partner Doug Morrow and the newest member of the ARE legal team, our law clerk Thomas Hart, will discuss a series of interesting cases involving street art, an attempt by such artists to assert copyright infringement against videos or photos incorporating these public displays. Fourth, my colleagues David Goldberg and Devin Garrity will discuss this year's major Supreme Court decision in copyright law, Google versus Oracle, involving the scope of fair use. The decision put to rest the long-running dispute between these behemoths over Google's appropriation of over 11,000 lines of so-called declaratory code involving Oracle's JavaScript. Next, my colleague Chris Lazinski will give us a preview of the copyright issue that the Supreme Court has already told us it will be tackling in the next term involving copyright registrations. Finally, my partner Tony Locicero and Thomas Hart again will discuss the CASE Act and the new small claims court that Congress established for low-value copyright claims. We hope you enjoy our presentation. Turning to our discussion on states' rights and responsibilities, my colleague Chandler Sturm will join me in discussing the two copyright cases decided by the Supreme Court in 2020. Both of these cases involve the rights and responsibilities of states in using and owning copyrights. The first case we will be discussing today is the U.S. Supreme Court case Allen v. Cooper that was decided in March 2020. Factually speaking, this copyright case determined the ability of states, like North Carolina in this case, to be immune from copyright infringement lawsuits under the copyright. Besides this important holding, the case is based on a fun set of facts. As Justice Kagan begins the opinion, in 1717, the pirate Edward Teach, better known as Blackbeard, captured a French slave ship in the West Indies and renamed her Queen's Anne Revenge, shown here. A year later, in 1718, the ship ran aground on a sandbar a mile off the coast of Beaufort, North Carolina. As Justice Kagan explained, quote, Blackbeard and most of his crew escaped without harm. Not so for the Revenge. She sank beneath the waters where she lay undisturbed for nearly 300 years, close quote. Fast forward to 1996, and a marine salvage company named Intersol Inc. discovered this infamous shipwreck. Under both federal and state law, the wreck belonged to North Carolina, but the state contracted with Intersol to take charge of the recovery activities. Intersol, in turn, retained Frederick Allen, a local photographer, to document the salvage. For more than a decade, Allen created videos and photos of divers' efforts to salvage the Revenge's guns, anchors, and other remains. He registered copyrights in all works.
This suit arose because North Carolina published without permission some of Allen's photos and videos. Defendants had moved to dismiss the complaint on the grounds of sovereign immunity. The district court recognized that the Copyright Restoration Act, commonly referred to as the CRCA and codified at 17 U.S.C. Section 511, states that no state is immune from suit in federal court for a violation of any of the exclusive rights of a copyright owner. Accordingly, in denying in part the state defendant's motion to dismiss, the district court reasoned that Congress had clearly stated its intent to abrogate sovereign immunity for copyright claims against a state. The district court also found that the abrogation had a proper constitutional basis under the Supreme Court's precedent in Florida prepaid, which we will discuss more later on. On appeal, the Court of Appeals for the Fourth Circuit disagreed and reversed the district court's decision. The Fourth Circuit reasoned that Congress's abrogation under the CRCA was equally broad and rested on a similar legislative record, as was the case with the corresponding Patent Remedy Act, which the Supreme Court found to be insufficient to support an abrogation of a state's sovereign immunity in the patent context.
Certiorari was granted by the U.S. Supreme Court, and in an opinion authored by Justice Kagan, the court held that Congress lacked the authority to abrogate the state's immunity from copyright infringement suits in the CIRCA. In particular, Justice Kagan's decision turned on the court's earlier analysis in Florida prepaid, which, as Chandler discussed, found that Congress' efforts to strip the states of their sovereign immunity from patent infringement claims lack a valid constitutional basis. Like the Fourth Circuit, Justice Kagan concluded that our decision in Florida prepaid compels the same conclusion for the Copyright Act, which was passed under a very similar record. The court's analysis begins with the fundamental principle of our constitutional scheme in the United States, as enacted in the 11th Amendment to the U.S. Constitution. A federal court may not hear a suit brought by any person against a non-consenting state. While Justice Kagan recognized the importance of this principle and the broad scope that it has provided, she also recognized that, quote, this court has permitted a federal court to entertain a suit against a non-consenting state on two conditions, close quote. First, Congress must have enacted an, quote, unequivocal statutory language, close quote, abrogating the state's immunity from suit. And second, some constitutional provision must allow Congress to have thus encroached on the state's sovereignty. Thus, the court applied this two-part test as shown here. As to the first part, Allen argued that it was easily met by the Circa, and Justice Kagan agreed that it was without doubt. In particular, Section 511A of the Circa clearly indicates such an abrogation. As Justice Kagan explains, quote, no one here disputes that Congress used clear enough language to abrogate the state's immunity from copyright infringement suits, close quote. The problem for Allen lay in the second part, over whether Congress was allowed under the Constitution to thus encroach a state's sovereignty. Allen turned first to the so-called Intellectual Property Clause of the U.S. Constitution, Article 1, Section 8, Clause 8. This clause gives Congress the authority to pass both patent and copyright laws. Unfortunately for Allen, this argument would require the court to overrule Florida prepaid, and the majority of the court was not willing to do so. Allen also pointed to Sections 1 and 5 of the 14th Amendment, which further modified Article 1, Section 2 of the Constitution. The court agreed that Sections 1 and 5 could provide a basis for Congress to abrogate a state's immunity from suit. The problem for Allen is that in order for this exception to work, the congressional abrogation must be tailored to, quote, remedy or prevent, close quote, conduct that infringes the 14th Amendment's substantive prohibitions. That said, the court did give way to bring digital blackbeards to justice. Congress, if it detects violations of due process, may enact a proportionate response. Justice Kagan was joined by Chief Justice Roberts and Justices Alito, Sotomayor, Gorsuch, and Kavanaugh in her opinion. Justice Thomas wrote a concurring opinion. Significantly, Justice Thomas took issue with the majority's, quote, special justification, close quote, standard for overruling the court's precedent, the court's endorsement of future 14th Amendment abrogation legislation, and the court's acknowledgement that copyrights could qualify as property thereunder. Justice Breyer also wrote a concurring opinion joined by Justice Ginsburg. The opinion maintained that the court, quote, went astray, close quote, in Seminole Triad, and, quote, erred again, close quote, in Florida prepaid. In Justice Breyer's and Ginsburg's views, the Intellectual Property Clause provides a sufficient basis to abrogate state sovereign immunity. However, they ultimately joined the court's judgment, recognizing that, quote, their long-standing view has not carried the day, close quote, and that precedent controls. Chandler and I will now look at whether copyright applies to states' codes. The U.S. Supreme Court recently looked at the matter in Georgia versus publicresource.org. This case involves the so-called government edicts doctrine, which generally holds that works authored by certain federal public officials in the course of their official duties are in the copyright public domain.
In particular, the dispute involved the state of Georgia's official code, called the Official Code of Georgia Annotated, or the OCGA. We will refer to the OCGA as the Georgia Code. The Georgia Code includes the text of all current Georgia statutes, as well as annotations to the text, which are not officially binding, such as summaries of judicial opinions construing the provisions of the statutes. The annotations to the Georgia Code were produced as a work for hire by Matthew Bender and Company, Inc., a third-party publisher of law books, for the Georgia Code Revision Commission, or the Commission. In 2013, the nonprofit organization public.resource.org Inc. purchased a full copy of the Georgia Code, including the annotations, and posted it online, allowing free public access to the Georgia Code on various websites. After sending Public Resource several cease and desist letters, the Commission filed an action for infringement of its copyright held in the annotations of the Georgia Code in the U.S. District Court for the Northern District of Georgia. The Federal District Court of Georgia ruled in favor of the Commission, reasoning that the annotations were eligible for copyright protection because they were not enacted by the legislator. The U.S. Court of Appeals for the 11th Circuit reversed.
The Supreme Court then granted certiorari. In a majority decision authored by Chief Justice Roberts, the U.S. Supreme Court held that the annotations in the Georgia Code were not eligible for copyright protection under the so-called government edicts doctrine. Chief Justice Roberts explained that under the doctrine, quote, officials empowered to speak with the force of law cannot be the authors of, and therefore cannot copyright, the works they create in the course of their official duties, close quote. The government edicts doctrine has deep roots and is based on the court's prior decisions dating back centuries, including Wheaton v. Peters from 1834 and Banks v. Manchester and Callahan v. Myers, both from 1888. In a democracy, the people are, quote, the constructive authors, close quote, of the law, and judges and legislators are merely draftsmen, quote, exercising delegated authority. Relying on this doctrine, the court here confirmed that the appropriate test is based on the identity of the author, judges, and we now confirm legislatures, may not be considered the authors of work when they produce in the course of their official duties as judges and legislators. Just as judges who have the authority to interpret the law cannot claim copyright in their decision under Banks, the same holds true for legislative bodies who have the authority to make the law. In short, quote, copyright does not vest works that are either 1, created by judges and legislators, 2, in the course of their judicial and legislative duties, close quote. Applying this two-step test to the facts of this case, the court found that Georgia's annotations are not copyrightable. First, the court determined that the commission, quote, is not identical to the Georgia legislature, but functions as an arm of it for purposes of producing the annotations, close quote. This, according to the court, was eminently clear from the membership staffing, funding, and procedure followed by the Commission in improving the annotations, as well as from the state law precedent that the Commission, quote, is within the sphere of legislative authority, close quote. Second, the court found that although the annotations are not enacted into law, their preparation is an act of legislative authority and they provide, quote, commentary and resources that the legislator has deemed relevant to understanding its laws, close quote. The court rejected several arguments Georgia raised. First, the court rejected Georgia's arguments that by listing, quote, annotations, close quote, as copyrightable works in Section 101 of the Copyright Act, Congress exempted this type of work from the government ethics doctrine. The majority ruled that Section 101 only applied to, quote, annotations which represent an original work of authorship, close quote. Second, the court also rejected Georgia's argument that a negative inference should be made from the fact that the Copyright Act explicitly precludes copyright protection for works of federal officials but not for state officials. Instead, the court opined, the federal rule does not suggest an intent to displace the much narrower government edicts doctrine with respect to the states. Finally, the court noted its concern with Georgia's argument in favor of limiting the government edicts doctrine based on only the content which has the force of law rather than authorship by a government official. Followed to its logical conclusion, such arguments would exclude not just annotations, but also concurring and dissenting opinions, headnotes and syllabi prepared by judges, proposed bills and committee reports prepared by legislatures, and other supplementary materials that, quote, do not have the force of law yet, close quote, but as the court observed, they are nonetheless, quote, covered by the doctrine, close quote. The court explained that these materials, although they don't have the force of law, are greatly important. As the court explained, imagine a Georgia citizen reading an unannotated copy of the Georgia Code, criminalizing broad categories of consensual sexual conduct with no hint from the annotations that the important aspects of those laws have been held unconstitutional by the Georgia Supreme Court. The majority opinion by Chief Justice Roberts was joined by Justice Sotomayor, Kagan, Gorsuch, and Kavanaugh. Justice Thomas filed a dissenting opinion, joined in full by Justice Alito, and joined in part by Justice Breyer. Justice Thomas objected to the majority's interpretation of the 19th century cases that formed the basis of the government edicts doctrine due to the narrower understanding of authorship and copyright protection current at the time, and agreed with Georgia's argument that the annotations should be eligible for copyright protection under the terms of the Copyright Act because they were not enacted by the legislature. In response to the majority's policy concerns, he noted that the practical effect of the majority's decision may well be that states would stop producing annotated codes altogether, which would render obtaining quality legal assistance even more expensive than it is now. Justice Ginsburg also issued a separate dissenting opinion, joined in full by Justice Breyer. Justice Ginsburg agreed with the two-part test set forth in the majority opinion as to whether the government edicts doctrine should apply. However, she disagreed with the majority finding the Commission's annotations were drafted by legislatures, quote, in the course of their legislative duties, close quote. She argued that since the annotations were not created contemporaneously with the statute, are descriptive rather than prescriptive, and were drafted for the convenience of the public, that they should not satisfy the second prong of the test. My partners Chester Rothstein and Holly Pekowski are now going to discuss this series of cases. Chester will lead the discussion with the first case, Sinclair v. Ziff Davis, LLC.
Section 106 of the Copyright Act provides to authors certain specific and enumerated rights. I think the most important of these rights is probably the right to reproduce or copy a copyrightable work. But what happens if a defendant in a lawsuit is an online publisher and it doesn't include the plaintiff photographer's image in his online article, but instead really merely includes a link which, when you click on it, redirects the viewer to the image housed somewhere else? We call that an embedded link. And so now what happens if that someplace else where the user is directed is Instagram? And further, what if it's an Instagram account of the photographer who has granted Instagram the right to publish, a right for anybody in the public to actually look at that Instagram page? In Sinclair against Ziff Davis, the website Mashable tried to get permission from a photographer named Sinclair to use one of her photographs, but that permission was denied. Mashable decided that they would do it anyway. But instead of putting the actual photograph in their article, they put an embedded link which linked to Sinclair's photograph on Sinclair's Instagram page. Sinclair sued. In the lawsuit, there were two possible defenses. The first, which was preserved but not actually made in the motion to dismiss, was the embedded link defense, saying that there wasn't a reproduction, there wasn't a copying, and therefore there was no copyright infringement. Under the old adage, without copying, there was no copyright infringement. The second was that under Instagram's policy, and the photographer posted her picture on Instagram in a public way that the public could get, they gave permission to Instagram to post it on Instagram, obviously. But secondly, they also gave Instagram the ability to sublicense it to other people for embedded posts. In this early part of the case, this motion to dismiss part of the case, Judge Woods made electronic publishers very happy. And she looked at the contract with Instagram between Instagram and the photographer, and they said, yes, indeed, that gives Instagram the right to use it, obviously, but it also gives Instagram the right to sub-license it to third parties like Mashable if the photographer's permission, which was granted to Instagram, was for anybody to use it. So if it was a public use on Instagram, then Instagram would be able to give a sub-license to parties like Mashable in order to use it on their own websites.
Now, our partner Holly Bukowski will discuss the second case in this series involving a different photograph posted on Instagram and a different judge in the same court, Judge Failure, who reached a different conclusion.
Hi, my name is Holly Bukowski, and I'll be discussing McCucken versus Newsweek. The basic facts of McCucken v. Newsweek are similar to those of Sinclair v. Ziff Davis, but the district court in this case actually reached a different result. So similar facts, but very different result. Photographer Elliot McCucken, he's a landscape and seascape photographer, and he maintains a public Instagram account, like many of us do. He posted a photo on his public Instagram of a normally extremely dry lake in Death Valley, suddenly filled to the brim with water, as shown by Exhibit A of the complaint lodged in the district court. Newsweek wrote an article the following day describing the phenomenon as the Salt Creek spectacle and embedded McCucken's photo in the article. Unlike Mashable, Newsweek did not seek a license to use the photograph. McCucken sent a cease and desist letter to Newsweek for the photo to be removed, but the article and the photograph remained on Newsweek's website. McCucken filed a complaint against Newsweek in the Southern District of New York, alleging copyright infringement. Newsweek then filed a motion to dismiss on the grounds that it was free to embed the photograph through Instagram's API under the Instagram's terms of use. Here's where things started to take a turn that was very different from Sinclair v. Davis. Unlike in Sinclair, where the district court accepted the argument that there was a sub-license granting to the entity using the API, Judge Failure did not find evidence of a license to use photographs through embedded links. Specifically, Judge Failure noted that while Instagram's various terms and policies clearly foresee the possibility of entities using web embeds to show others content, none of them expressly grants a sub-license to those who embed publicly posted content. As a result, the district court ruled in McCucken's favor, denying the motion to dismiss.
Chester will now continue the story.
So then after McCucken, which Holly just told you about, the case came back to Judge Woods, who read the opinion by the court in McCucken, and she said, I'm persuaded by that. So she granted a request for reconsideration and reversed her decision to grant the motion to dismiss. The case continued. After that, we don't really know what Instagram was thinking, but they reversed their own policy. They put out a release that said, well, we are entitled to grant sub-licenses. We want everybody to know that we're not doing that anymore. There are no rights to put embedded links to Instagram into your own articles. And if you want to use those pictures, you can't do it through the embedded links. You have to get your own permission from the photographer. So where we are left is that electronic publishers no longer have the defense of contract of a sub-license from Instagram, but they are still left with the underlying substantive question: is it a copyright infringement if you don't copy the work on your website but just have an embedded link to it? We are waiting for new courts and new cases to help us answer that question.
My partner Doug Morrow will tell us about how copyright law applies to street art and about a recent case involving a prominent mural.
Street art, like traditional art forms, is automatically protected by U.S. copyright law. However, the enforcement of copyrights in street art is often difficult in the U.S. given the available defenses to copyright infringement, such as fair use and de minimis copying. A fair use defense typically relies upon analyzing four factors: the purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the portion used, and the effect of the use on the potential market for the copyrighted work. For the purpose of this presentation, we're going to focus on only two of the factors: the purpose and character of the use and the effect of the use on the potential market for the copyrighted work. My colleagues David Goldberg and Devin Garrity will discuss these in greater detail when they discuss fair use in the context of the Google versus Oracle case. Infringement of copyrighted works in general only occurs if the works are substantially similar. If the amount of work copied is only de minimis, or is so trivial as to fall below the quantitative threshold of substantial similarity, then no infringement occurs. As it is sometimes put, the law does not concern itself with trifles. Two recent cases involving alleged infringement of street art help to show these factors at play. The first case is called Blaney versus XYZ Films LLC. This particular case, the XYZ Films case, demonstrates both of these defenses in action. In March 2020, the Eastern District of New York granted a motion to dismiss a copyright infringement claim and a claim of false endorsement by a mural artist. In general, the court found that the use was either de minimis or fair use of the copyright. The mural in question was made by the plaintiff, who the court characterized as an artist and activist nationally recognized for producing works that evince her commitment to human rights and social justice. The mural depicts the co-plaintiff Blaney and is located at a street corner in Bushwick, Brooklyn. The subject matter of this case is a 93-minute action film entitled Bushwick, in which the mural appears in a 3.5-second shot in the opening scene. The plaintiffs claimed that the work infringed their copyright in the mural because XYZ Films presented the mural in a full-screen shot in perfect focus and unobstructed to the viewer for several seconds. So after careful consideration, the court found that this copying was de minimis. The court said plaintiff's description of the mural in the film was grossly overstated, and instead of being in perfect focus, was at all times in the background, where obscuring the view of at least 1/3 of the mural rests a red pickup truck, and throughout the entirety of the 3.5-second scene, an actress prominently positioned in the foreground runs about, further obscuring the mural. As a result, the court found that this de minimis use resulted in no infringement. The court also found that even if the use was not de minimis, it was fair use. Applying the character and purpose prong, the court ruled that the use was transformative because the purpose was to locate the film's viewer at a specific subway station in Brooklyn, not to copy the expressive function of the mural, which the plaintiff characterized as conveying a message of peace. The court also held that the market effect fair use factor weighs heavily in defendants' favor because the target audience of the film is drastically different from that of the mural. Additionally, the court found it does not falsely imply that the film was endorsed by the mural's author or by the subject depicted in the mural.
Our law clerk, Thomas Hart, will discuss how the same legal principles apply in Gale versus Ailey.
In January 2021, a U.S. federal district court in the Southern District of New York considered similar issues, granting a motion to dismiss the copyright claims of pro se plaintiff Gale. Gale holds U.S. federal copyright registrations for 8 photographs, entitled Art We All, and for a further 13 photographs entitled Art We All Group Registration Photos. These generally depict his graffiti phrase containing the phrase, Art We All. Gale filed suit alleging claims of copyright infringement against the photographer and the gallery exhibiting and offer for sale a photograph that depicted graffiti tagged with the words Art We All One and with the title Art We All One. As you may be able to see, visible in the bottom right corner of the photograph is a small construction barrier tagged with graffiti reading Art We All One. Gale, in 2 separate complaints, did not identify which photos had been infringed, and the court held that, among other reasons, Gale failed to adequately plead a copyright claim. The court went further. As in the previous case, the court also concluded that Gale's copyright claim failed because any alleged infringement was de minimis. Gale, however, attempted to argue that the similarity of the copyrighted material, the closeness of the products, and defendants' lack of good faith demonstrated that defendants' use of the copyrighted material was not de minimis. The court disagreed. Specifically, the court noted that the photograph was on display only at one exhibition at the gallery in 2017, which favored a de minimis ruling. Moreover, the court reasoned, although the photograph is titled Art We All One, the actual graffiti appears in small print in the bottom corner of the photograph in a manner that is far less prominent than the apartment buildings that dominate the vast majority of the photograph and even less prominent than other items in the photograph. Accordingly, the court determined that any alleged infringement concerning the use of the "Aren't we all one" phrase was both qualitatively and quantitatively de minimis, such that it could not support an infringement claim. It also noted that the courts generally reject the claim that the use of a copyright in another image without more is anything more than de minimis. Interestingly, the court did not conduct a fair use analysis, noting that a complex evaluation of the factors was unneeded since no infringement occurred.
As these two cases show, it can be difficult for street artists to protect their copyrights. There are other risks. For example, under the Copyright Act, if the artist is unable to establish liability, it risks the defendant's recovery of attorney's fees as the prevailing party. Even if the artist is able to establish liability, it still may be difficult for the artist to show defendant's profits attributable to the infringement, the artist's actual damages, or enhanced statutory damages for fleeting de minimis use, for example, as part of a one-off social media campaign. Moreover, if the work isn't registered prior to the alleged infringement, it would be even more difficult for the artist to obtain a worthwhile economic result. This is because the artist would not be able to obtain statutory damages or collect attorney's fees, and any monetary award would be limited to either the defendant's profits or the artist's actual damage, which I just mentioned would be difficult to show. Typically in copyright cases, the threat of being able to obtain attorney's fees gives the plaintiffs leverage to obtain a more favorable economic recovery.
Next, we will be discussing fair use in the context of the Supreme Court's decision in Google versus Oracle. My colleagues David Goldberg and Devin Garrity will discuss how the majority and the dissent disagreed in this case.
The Supreme Court's April 5, 2021 decision in the long-running dispute between Google and Oracle concerned Oracle's assertion of copyright infringement by Google for taking over 11,000 lines of so-called declaring code relating to the Java programming language. In this decision, Justice Breyer, writing for the majority, found that Google's use of Oracle software was fair use. Justice Breyer was joined by 5 other justices, including Chief Justice Roberts and Justices Sotomayor, Kagan, Gorsuch, and Kavanaugh.
Justice Thomas wrote a substantial dissent, which was joined by Justice Alito. Justice Barrett recused herself and took no part in the decision.
Let's begin by talking about the software code in question. In the majority opinion, authored by Justice Breyer, he made a point of distinguishing the declaring code that the case was about from more familiar code such as implementing code. Devin, what's the difference between declaring code and implementing code?
Thanks, David. Java is a programming language developed by Sun Microsystems. It uses code to program things like websites, computers, and other devices. The programming platform has both declaring code as well as implementing code. According to the court, the code used to describe each of the functions to be performed is the declaring code. That is the specific software at issue in this dispute. The court describes implementing code, on the other hand, as code that tells the computer how to execute a particular task that a developer has asked it to perform. Most of the time, when people are talking about copyright software, they are talking about the implementing code and sometimes the graphical user interfaces that go with that code. In deciding that Google's use of the declaring code was fair use and thus did not infringe on Oracle's copyright, the court considered the 4 traditional fair use factors. These are 1. The purpose and character of the use, including whether such use is of a commercial nature or is for non-profit educational purposes. 2. The nature of the copyrighted work. 3. The amount and substantiality of the portion used in relation to the copyrighted work as a whole. And 4. The effect of the use upon the potential market for or value of the copyrighted work. These factors are found in Section 107 of the Copyright Act.
The court actually started its analysis in this case by looking at the second factor, the nature of the copyrighted work. As you noted before, Devin, this case involves declaring code that offers programmers a simple way to access pre-written code using simple commands. The majority reasoned that the value of this declaring code lies in the fact that computer programmers who have learned the code can use it to do different things, not in the way the code solves problems or performs particular tasks, which is what implementing code does. Accordingly, the majority thought that the nature of this copyrighted work was far from the core of copyright, and more analogous to uncopyrightable ideas related to task division and organization than to the creative expression close to the core of copyright that is represented by implementing code, which uses the nuts and bolts of declaring code to solve problems or perform particular tasks. Interestingly, the majority declined to analyze whether or not declaring code would qualify for copyright protection as a matter of law.
Justice Thomas argued in his dissent that this distinction is untenable, and that all copyrighted works contain a mixture of elements that are either closer or more distant from the core of copyright. For instance, he writes, books are inherently bound with uncopyrightable ideas, the use of chapters, having a plot, or including dialogue or footnotes. This decision does not place books far from the core of copyright. Code, the dissent thought, should be treated the same way, because implementing code and declaring code are inherently bound up with one another. Thomas also explicitly says that he would hold that declaring code is protected by copyright.
The court next looked at the first fair use factor, the purpose and character of the use, concluding that the factor favored Google. The majority found that Google's use was transformative. According to Justice Breyer, Google's basic purpose was to create a different task-related system for a different computing environment, smartphones, and to create a platform, the Android platform, that would help achieve and popularize that objective. As a result, the purpose and character of Google's copying was transformative, weighing in favor of fair use.
Justice Thomas conceded that this was the one factor in his view that might favor Google, since commercial uses are sometimes transformative. That said, Thomas went on to argue that the majority's analysis confused transformative use with derivative use, since, in his view, to be transformative, a work must do something fundamentally different from the original. A work that simply serves the same purpose in a new context, that is, cell phones, not computers, is derivative, not transformative.
Moving on to the next factor, the court considered the amount and substantiality of the portion used in relation to the copyrighted work as a whole. Justice Breyer and the majority pointed out that although Google copied 11,000 lines of code, the whole Java program contained over 2.8 million lines of code. Accordingly, Google only copied 0.4% of the total lines of code. Therefore, the amount of code copied was small.
Justice Thomas, on the other hand, noted that the proper point of comparison should be to the declaring code. Thus, while it's true that Google only copied a small portion of the Java API, Google also copied all of the declaratory code. The factor, therefore, favored Oracle in his view.
Finally, with regard to the effect of the use upon the potential market for or value of the copyrighted work, Justice Breyer found that the factor, like the others, favored Google. Justice Breyer pointed to evidence showing that Android is not a market substitute for Java software, and that Oracle would benefit from the broader use of the Java programming language in a new platform like Android, which would further expand the network of Java-trained programmers. He also argued that allowing enforcement of Oracle's copyright here would create creativity-related harm to the public by restricting the ability of programmers to create innovative software.
Justice Thomas, on the other hand, argued that copying greatly harmed Oracle. Google's inclusion of Oracle's code in its Android operating system, which was provided for free to device manufacturers, directly undercut Oracle's effort to license Java to those same device manufacturers. And in response to Breyer's policy argument, Thomas replied that Apple and Microsoft created mobile operating systems without using Oracle's code, and that the suit in any event only regards versions of Android released through November 2014.
Although the majority did not go so far as to declare that the code it issued did not qualify for copyright protection, it did note that the nature of this copyrighted work was far from the core of copyright. This represents a victory for the principle of interoperability in the software field. That said, whether software companies now start to turn more to patents and trade secrets to protect their code is something that remains to be seen. It's interesting that the first appeals court case to parse the details of this decision deals with the fine arts and not software at all. In the Andy Warhol Foundation versus Goldsmith, where Warhol's estate is appealing a district court decision against its fair use defense, the Second Circuit specifically requested briefing as to whether Oracle v. Google should affect its decision. This shows that, although the Supreme Court's ruling in Oracle was theoretically quite limited and did not overturn any precedent or assert new legal principles, it does extend beyond the realm of software, has the potential to support more nuanced approaches to the fair use analysis, and likely will help defendants who are able to argue more broadly the transformativity of their allegedly infringing uses of copyrighted work. It will be very instructive to see how the Second Circuit uses the Oracle decision in the Warhol case going forward.
Our next topic is copyright registrations. Chris Lazinski, an associate with the firm, will be presenting. Chris.
Thanks, Charlie. One interesting copyright case that deals with copyright registration currently before the U.S. Supreme Court is Unicolors versus H&M. Unicolors is a fabric company that sued H&M for copyright infringement. After a jury verdict in favor of Unicolors, H&M renewed a motion for judgment as a matter of law, on the grounds that 17 U.S. Code Section 411 requires the district court, if there is inaccurate information included on the copyright application, and if it was known to be inaccurate, to refer the matter to the Register of Copyright, so that it can advise the court whether or not it would have refused registration had it known of the inaccurate information. The Federal District Court for the Central District of California denied the motion, suggesting that there was an intent to defraud requirement before referral was necessary. On appeal, the Ninth Circuit, however, reversed, holding that there is no such intent to defraud requirement. After reversal, Unicolors petitioned the Supreme Court for review of the case. The petition presented two questions. First, did the Ninth Circuit err in breaking with its own prior precedent and the findings of other circuits and the Copyright Office in holding that 17 U.S. Code Section 411 requires referral to the Copyright Office where there is no indicia of fraud or material error as to the work at issue in the subject copyright registration? And second, did the Ninth Circuit misapply the publication standard by both applying Copyright Office requirements that were not in place at the time of the registration and analyzing publication as of the date of registration as opposed to the later registration application date? And if so, did the evidence support referral to the Copyright Office? On June 1st of this year, the U.S. Supreme Court granted cert, limiting its upcoming review to only the first question presented by Unicolors, if there is an intent to defraud requirement. This is the first time that 17 U.S. Code Section 411 has come before the court, and it should be interesting to see whether the court adopts a plain language approach or instead requires there to be an intent to defraud.
We will conclude our discussion today by talking about the Case Act and the new small claims court set up for copyright disputes. Speaking on this topic will be my partner Anthony LaCicero, as well as our law clerk Thomas Hart.
Good afternoon. In late 2020, Congress passed the Copyright Alternative in Small Claims Enforcement Act, or CASE Act, which set up a small claims court for copyright disputes that fall into certain categories. Our law clerk, Thomas Hart, will now explain the background and procedures of the act, and I'll follow on a little later.
Many copyright claims are low value, and for many independent creators and small businesses are more expensive to pursue than they're worth because of attorney's fees and other costs. A broad category of creators have no reasonable remedy to pursue in these cases, de facto allowing certain forms of infringement. Congress decided to act, and as you noted, pass the Copyright Alternative in Small Claims Enforcement Act of 2020, or the CASE Act. The CASE Act was designed to provide a way for independent creators and small businesses to be able to protect their copyrights. The CASE Act provides a venue, the Copyright Claims Board, where creators can seek damages which would ordinarily be too low to justify bringing an action in federal court, or the cost of bringing an action would be too prohibitive. The board is composed of 3 officers who are attorneys with 7 years of experience. Officers are appointed by the Librarian of Congress, upon suggestion by the Registrar of Copyrights, and conduct hearings, as well as issue final written decisions. 2 of the board officers must have experience presiding over or presenting on copyright claims for both owners and users of copyrighted works, And the third must have substantial familiarity with copyright law as well as experience in the field of alternative dispute resolutions. The board can hear cases alleging copyright infringement, seeking declarations of non-infringement, and involving disputes revolving around notices and counter-notices under the DMCA. The Case Act also lays out the basic procedure which the board will use in hearing claims. Before a complaint is filed, the copyright holder and the accused infringer may engage in negotiations. It's also possible that they are referred to the board by a federal district court, which is able to use the board as a form of alternative dispute resolution. Assuming that negotiations are unsuccessful, the first step in a proceeding before the board is for the claimant to file a claim with the board. They must include a statement of material facts, certify that the filing is accurate, and pay a filing fee of at least $100. They may file a complaint even without having an attorney. They are, however, limited to seeking only $30,000 in damages and must have applied for a copyright on the infringed work. The second step is for the board's attorneys, who are copyright attorneys with at least 3 years of experience, to review the claim. If there are deficiencies, they will notify the claimant, who may submit an amended complaint within 30 days for free. They may do this twice before the claim is dismissed without prejudice. Third, the claimant conducts service on the respondent and files proof of service with the board. The board will also issue a notice to the respondent to ensure they are aware of the complaint. At the fourth step, respondents have 60 days to opt out of the proceeding. If they do, then the proceeding stops, with no adverse penalty to the respondent, making the entire procedure entirely voluntary. If the respondent does not opt out, then the proceeding continues. The fifth step is really a series of steps. The board will conduct a scheduling order. There will be limited written discovery between the parties, usually consisting of answering written interrogatories, and the board may conduct conferences. There are 3 ways forward from here. First, the board may decide to dismiss the case, for example, because the case is outside the scope of its competence. Second, the parties may settle the case. And third, the case continues. If it does, the board will issue a written decision as the 6th step. The board will use a preponderance of the evidence standard for factual decisions and will make rulings based on federal copyright law. The decision of the board is binding on the parties, but the board can only grant limited monetary damages and cannot order a party to stop an infringing activity without that party's consent. Depending on the ruling, either party may request reconsideration within 30 days from the board, identifying a clear error of law and fact, and if the request is denied by the board, may, within 30 days of the denial, request review from the Register of Copyrights, who will review the decision for abuse of discretion. Additionally, these parties can, within 90 days of the latest action by the board or the register, or within 1 year in the case of a default judgment, seek a limited appeal at a federal district court.
Thank you, Thomas. As we said earlier, the basic trade-off of the Case Act is that it provides a low-cost venue for individuals and other copyright claimants who could not otherwise have the resources to file a case in federal court to be able to obtain redress for alleged violations of their copyright. It's supposed to be low cost in that the filing fee has to be $100, but must be less than the filing fee for federal court litigation. There must be the ability to bring infringement claims and counterclaims, to seek a declaratory judgment of non-infringement, and to challenge notices under the Digital Millennium Copyright Act, or DMCA, as well as counter notices under the DMCA. There are simplified proceedings. There's no requirement that an attorney be present for either party. There are limited costs that can be allowed, and we'll get to that in a second, and there are limited damages. There are damages that are limited to $15,000 per infringement and $30,000 per action. It is, importantly, a voluntary procedure in that the defendant can always opt out. And that's, of course, very important because the Seventh Amendment guarantees the right to a jury trial in actions at law, which include claims for copyright infringement where damages are requested. There can be no injunction, but the parties can enter into an agreement to cease their conduct. And parties that do this all day and do it very regularly can be barred from having these proceedings dismissed. But here are the potential pitfalls. So first, there's limited discovery, and the limited discovery is paper discovery. So it sounds like no depositions except for a good cause, but there are document requests, interrogatories, and written requests for admission. If I tell the average copyright proprietor, who is an individual author or musician or sculptor, that he has to respond to requests for admissions, then he'll understand he has to get a lawyer. So the permission of this kind of written discovery, rather than the simple exchange of documents, means that in fact there will have to be legal representation on behalf of the complainant. It just doesn't really work otherwise. There is a potential for a protective order to limit the disclosure. Certainly a defendant is going to seek a protective order. And again, I don't really see an individual non-attorney being able to successfully negotiate a protective order with attorneys for a record label. And of course, there may be an adverse inference with respect to disputed facts against a party who has failed to provide discovery materials. Once again, this is the kind of thing that will be difficult for a non-lawyer to navigate. There's another possibility that exists in the way the statute was drafted, which may well provide a deterrent for individuals, and that is the award of attorney's fees. We all know that the copyright statute permits in some circumstances the award of counsel fees on behalf of a prevailing party. In the Case Act, in Case Act proceedings, then the statute says that in a proceeding where it's been determined that there is harassment or improper purpose, or a defense has been made without a reasonable basis in law or fact, then the board shall, interestingly, award attorney's fees in the amount of no more than $5,000, except that a pro se plaintiff is only on the hook for $2,500. So that's interesting. I'm afraid that what will happen in practice is that the defendants or respondents will often say that this claim was made in bad faith, and that if they prevail on the bad faith allegation, then they're going to seek the award of which appears to be mandatory, they seek an award of damages for bad faith, bringing of a claim under the Case Act in an amount of $2,500 from a pro se individual or $5,000 for someone represented by counsel. That alone may well deter commencement of an action, especially when an individual is confronted with the possibility that he can only win $15,000, but if the respondent is able to prevail in his claim of bad faith, then the pro se plaintiff's on the hook for $2,500. It simply may not be worth the risk. And finally, a potential pitfall is in the possibility of appeals. Not later than 90 days after a determination, then there can be an appeal if the decision was based on as a result of fraud, if the Copyright Claims Board exceeded its authority, or if it's a default case, it was based on excusable neglect. Now, these are very similar, of course, to the standard appeals that are possible from arbitration awards. They're very rare, but again, they are possible. And if an appeal is filed, then there's no doubt that the complainant will need to engage an attorney to prosecute the appeal. So in sum, the Case Act is a very valuable addition to the copyright regimen. It does provide, as intended, a vehicle and a venue for small copyright claimants to seek to enforce their rights up to a certain statutorily limited amount. But there are limitations which suggest that, in fact, these claimants are best advised to engage an attorney to help them navigate even these simplified procedures. So thank you very much for your attention.
Thank you, Charlie, and all the speakers, and thank you all for joining us today. As I mentioned, do take a look at the article on our website. It forms part of a large collection of roundup articles on topics ranging from China trademarks, European fashion law, German patents, so do take a look. Thank you.
To learn more about these hot topics, please read the article in Journal of Intellectual Property Law and Practice that this presentation is based on. Amster, Rothstein & Ebenstein LLP also frequently publishes law alerts providing updates and information on the latest cases in copyright law at arelaw.com/publications. Another great source of information is the Amster, Rothstein & Ebenstein LLP LinkedIn. Follow for the latest updates.